retired justice from the Sandigan Bayan. Actually, I am violating already our rules here because it is said here that I just have to read what is written here. But anyway, to break the monotony, I began as a trial judge, and as a trial judge here in the Philippines, especially if you are a municipal trial court judge, if you violate procedural fairness, the Supreme Court will call that ignorance of the law. If you are an RTC judge here and you violate this procedure, you misappreciated the facts of the case. If you are an appellate court judge, we call it error in judgment. If it is the Supreme Court that commits procedural unfairness, it forms part of the law of the land. And with that, good afternoon. We will have two lecturers this afternoon. The Honorable John P. Ehrlich, who said that P is for Philip. I will ask him to change this for purposes of this lecture. The word P will stand for Palatao. All right. Now we don't have the luxury of time. May I have the pleasure to call on Judge Honorable John P. Ehrlich, Judge King County Superior Court of the USA, to deliver his paper on justice on trial. One key to public confidence and trust in court. Judge Ehrlich, you are welcome to deliver your lecture.
Thank you, Judge. Thank you. Salamat. Good afternoon. Bonjour. Buenas tardes, boa tarde, Magadan hapun. It's a great pleasure to be here this afternoon co-presenting with Justice Palatao as well as Judge Gaite Landeral. As Justice Palatao just mentioned, I am an incumbent judge on the King County Superior Court, which is a trial court of general jurisdiction. But more importantly, what you should know is that I'm also an adjunct professor at Seattle University School of Law. Why is that important? Well, you are now all of my students. And for those of you who have not attended American or Anglo law schools, we use what is called the Socratic Method. The Socratic Method is named after Socrates, and what Socrates did is he took all of the students and put them in a circle, and then he asked them questions. And I'm not going to do a lot of that for you this afternoon, but if that puts fear into you, you can either tell me, just don't call on you, or you can leave. So, with that said, you know who I am. I want to know who you are. And I know some of you. How many of you are judges? Okay, and are we retired yet? You don't know that. Now, how many of you are educators? And how many administrators? Staff people? Prosecutors? Other? Something else? Okay, I know Tom does. And you, what's your work?
Check 1, 2. Low.
A professor. Okay. So you can appreciate the role I'm in probably, I'm sorry, for recording? You need this? Okay, okay. So I'll use this even though I usually don't need it, but I'll use it anyway. Test, test. Okay. So, what are we going to talk about this afternoon? What we're going to talk about is justice on trial. Procedural fairness may be a term that's familiar to some of you, but not all of you. Procedural fairness is a means of obtaining public confidence and trust in our court system. Did I just do something really bad? There we go. So, public trust and faith in our judiciary is fundamentally based on what we've been talking about this entire conference: the independence and impartiality of judges. It's a universal principle. It shows up in a number of sources in the Vienna Convention, as well as with other sources as well. It's a principle that's been adopted universally in international law and in the law of almost all of the jurisdictions represented at this conference. This is one of my favorite sayings, which is those who forget the past or cannot remember the past are condemned to repeat it. George Santayana, who was an American philosopher. And I bring that to you because almost everything that I bring to you this afternoon has occurred, is occurring currently in many of our nations, but has occurred also over time in the past. And when we forget the past, we forget the fact that we can overcome this. And there are tools that I'm going to be talking about that can fight back against some of the challenges and attacks that we have had on the judiciary in my own country, in the United States, as well as in many of your countries. So, what we're looking at is attacks on the judiciary and ways of overcoming that. What we will be addressing this afternoon is public confidence in the judiciary and how it's affected by procedural fairness as well as judicial demeanor. I'm going to start with some recent events in the United States which involve delegitimizing and politicizing the judiciary, and then give some historical context to those events. Then I'm going to delve into some evidence-based, conceptual, and statistical studies looking into public confidence and trust in the judiciary, both in the United States as well as internationally, current trends with public confidence, and how these are affected by judicial demeanor and conduct. Then I'm going to conclude with some practical ideas about applying public confidence and procedural fairness. And then I'm going to turn over to my colleague, Judge Gaite Landeral, for some of her experiences with regards to the application of procedural fairness in Filipino courts. Keep doing that, okay? So, let me just note, I'm going to start with some of the experiences that we have had in the United States with respect to attacks on the judiciary. Some of you may be familiar with this. This was a fairly recent comment earlier this year made by our president, Donald J. Trump. And it was about a federal judge in my jurisdiction in Washington State who issued a travel ban. And you may have more recently heard President Trump criticize our judiciary and call it a laughingstock and a joke. Now, I want to assure everyone here, as a judge in particular, I'm not intending to be political. But all of us in the judicial system, either our colleagues or ourselves, have been criticized by external forces or have individually been attacked. And so that's what we're going to be looking at is in the United States, there's a long history of attacks on the judiciary and on judges specifically. And the purpose of these attacks is to undermine the authority and public confidence in our courts. Chief Justice Roberts of the United States Supreme Court noted recently the increased partisan hostility over the courts and over judicial appointments. So what can I tell you about these attacks and about this criticism? First of all, it's not new. It's as old as the Republic of the United States is, and it goes back over 200 years. Secondly, occurrences of attacks on the judiciary ebb and flow over time. Third, it's universal. We have attacks on the judiciary in the United States, but also recently you've heard about attacks on the judges in Kenya, attacks on the judiciary in Pakistan, attacks on the judiciary in Poland, in the Ukraine, and in the Philippines. This is a universal problem that we have because the other branches of government do not like when the judges in the judiciary assert their power. And unless there is a dictatorship that allows for removal of judges, what they do, and when I say they, I mean the executive or the legislative, attack us individually in our decisions to undermine the public confidence in our courts. Because that's all we have. And what we're going to be tying in later in the session is the fact that procedural fairness is one way to overcome these attacks and to enhance that public trust in our courts. Studies show that one of the most effective means for enhancing public confidence and trust is procedural fairness and judicial demeanor. This is another example of an attack in the United States where President Trump said, I can't get a fair trial because the judge is Mexican and I've threatened to build a wall. The impact that we have when we are attacked is not on our individual courts, but it's on the court system and the judiciary as a whole. And one of the problems we have is that the media, and I'm not, again, not here to criticize the media, but the media wants to promote itself. And so it's not going to show my courtroom. In fact, I had the media in my courtroom and they left after 2 days because I think I was too boring of a judge. There were no antics. I didn't yell at anybody. No lawyers yelled at me and they pulled out. And so what do we see on TV? On TV or on YouTube, what we see is a Florida judge who has a public defender, a public defense attorney in his courtroom. He starts arguing with the public defense attorney and then says, okay, we're taking this outside. And they go outside and what you hear is a fight, a physical fight between the judge and the lawyer. This is what the public sees. And this is what the media focuses on. And therefore, when we're criticized, it enhances, it reinforces that negative image of judges and the court system. And so we as judges and you as educators have to teach methods to judges as to how they can be perceived as more fair and even-handed in their courtrooms. Because it's not just the litigants, the parties in the courtroom. It's everyone who observes that judge while they're in the courtroom or what they see on television. This is another case. Again, I'm not going to spend a lot of time on American cases, but this was the Terri Schiavo case where the Florida judge, a different Florida judge, had to deal with a battle between a woman's husband and her family, her parents. And this is a woman who was on life support. She was essentially brain dead. Her husband wanted to remove the life support. Her parents went to court to try to challenge that. The judge was in favor of the husband, saying he got to make that decision. It became a cause célèbre for the right to life movement. Our Congress got involved. George W. Bush got involved, our president at the time, and there was a big controversy over this where Congress unsuccessfully attempted to essentially overturn the decision of the Florida judge. There were elected officials, again from other branches of government, who said judges are going to have to answer for their behavior, and criticized judges as being activist judges. And this was an instance where judges were being physically attacked. One judge in Chicago was murdered. And again, one of our elected United States senators blamed the victim, blamed the judge, and said, well, if they don't want to be attacked, perhaps they shouldn't make such unpopular decisions. We don't make unpopular decisions on purpose. We make unpopular decisions because we are interpreting the law as either passed down by the legislature or by precedent. And that's our responsibility, that's our obligation. We're not elected officials who have to choose which decision we want to make. We are required to follow the law. So historically, going back, we've got President Truman, who appointed his Justice Thomas Clark. He didn't like some of the decisions that Justice Clark made, and he said, it's not he's such a bad man, it's just that he's such a dumb son of a bitch. So this isn't anything new. Teddy Roosevelt, I could carve out of a banana a judge with more backbone than, let's see, I'm trying to remember which justice it was. It was another justice, it was Oliver Wendell Holmes, who Teddy Roosevelt had appointed. Before that, we have Andrew Jackson, President of the United States, telling Chief Justice Marshall, you might tell me that I can't remove these Cherokee Indians from Georgia and make the move to Oklahoma, but how are you going to enforce your decision? And that was a real constitutional crisis in our country going back to the early 1800s, 1822. And then harking back to the very founding of the Republic, President John Adams asked Justice John Jay if he wanted to stay on as Justice of our Supreme Court, and he said, why would I? He said, it's a system so defective that it does not possess the public confidence and respect which the court of last resort should hold. So it's nothing new that we are facing in our country, the United States, or that you face in your own countries. And so what we need to do is recognize that there is an ongoing effort that ebbs and flows to undermine public trust and confidence in our judicial system. This is from one of our Congresswomen, Barbara Jordan. What America wants is an America as good as its promise. What people want are courts that are as good as their promise. Courts that are fair, courts that are efficient, and courts that are effective. So, one of the issues, and I know they're talking about this in the other sessions, one of the issues that we always have as judges is, what do we do when we are attacked? What's human nature? This is the Socratic part. What's human nature when we're attacked? Fight back. Exactly. So what do you think Judge Curiel, who is the judge who, he wasn't Mexican at all, his parents were Mexican, he was actually born, I believe, in Indiana, so he was a Midwesterner, he wasn't a Mexican. But what do you think Judge Curiel did when Donald Trump criticized him and said, I can't have a fair trial before that Mexican judge? Any guess? Pardon? He did not engage. He did not engage. And this is so important because our human nature is, if he tweets against me, I'm going to tweet right back. And we see this constantly in American politics now, and I'm sure that you see this in your own governments where you have the president criticize somebody in your legislature or in your state assembly, and that person fights back and it becomes a media fight. Judges cannot do that. And if he had done that, he would have played right into the president's hands, and which would have resulted in exactly what he wanted, which is the judge recusing himself and taking him off the case. So let me ask, for those judges here, how many of you have been criticized? How many of you have ever been criticized? Okay, so I know I have. You know, either directly with somebody say they didn't agree with my decision, or in the media, or what have you. But, you know, people will criticize our decisions. So let's take a look at some of the ethical rules that provide us with some guidance. The American Bar Association establishes model rules that are sent out to each of the 50 states. And all 50 states have adopted some form of the model rule. The principles behind the model rule parallel the principles in the Bangalore principles. They are very similar in terms of an independent, impartial judiciary, and that is first and foremost its primary goals. So we have Rule 1.2 in the ABA. And the key here is impartiality, independence, and integrity. Impartiality, independence, and integrity. And this is what I call the 3 I's. Independence, integrity, and impartiality. It is the theme through all of the rules, the model rules passed by the ABA, adopted by the states in the United States. So, we are supposed to act at all times that promotes public confidence in our impartiality, integrity, and independence. So going back to Judge Curiel, if he engages with President Trump in a conversation about his case, he is undermining the public confidence in his ability to be independent. And under the rule, there are comments. The rules acknowledge, and this is quite important, the rules acknowledge that as judges, we often are forced to make unpopular decisions, and we can be the target of scorn or criticism. So comment 2 says, a judge should expect to be the subject of public scrutiny that may be viewed as burdensome, applied to other citizens, and must accept the restrictions imposed by the code. What does that mean? That means, for example, that when we are criticized, we cannot go to the media and explain our decisions. We cannot often defend ourselves personally as a common citizen might be able to. And again, the comment notes, the conduct, the compromise, the independence, integrity, and impartiality of a judge undermines public confidence in the judiciary. So, I want to go back now to the Florida judge who punched out the lawyer. That did not just bring that judge into disrepute, but it brings the entire judiciary into disrepute. So when judges engage in certain behavior in the courtroom or outside the courtroom, this confirms, this is what we call confirmation bias. This confirms what a lot of people think about judges. Because I don't know if you have Judge Judy in your country or not, or something similar, but we have these reality TV judges. And they go on TV and they hear these cases and they act injudicious. And so for people who've never been in a courtroom, sometimes they think this is the way judges actually act. Or someone will look on TV and see the judge who's punching out the lawyer, and this is how they think judges act. And it just takes an individual judge to undermine public confidence in the entire judiciary. So, we also have Rule 2.10. Rule 2.10 prevents judges from talking about cases that are pending in their courtroom. Why is that? Reason for that is a judge isn't supposed to make a decision until he or she has heard all of the evidence, all of the facts, and the law has been argued to the judge. And so if we're talking about our cases, we may be prejudging what we're going to decide in a case. We may also subject ourselves to outside influences such as criticism. So what type of a public response can we make as an individual judge if one of our decisions is being criticized or our behavior in the courtroom is being criticized? Comment 3 under 2.10 says, depending on the circumstances, the judge should consider what may be preferable for a third party, rather than the judge, to respond or issue statements or connection with allegations concerning the judge's conduct in a matter. So, by responding individually, I'm going to make it look political. I'm going to make it look, I'm just defending my decision. But if I have a public information officer, or what we have in my state is a fire brigade. What does a fire brigade do? A fire brigade puts out fires. And how do fires occur? Well, if a judge has before him someone who has been charged with a very serious crime, such as sexual assault, but this person has ties to the community, they've posted a large bail, he lets this person out. That judge may be subject to criticism. That judge can't go to the media, on TV, or to newspapers and try to explain his decision. So we have a group of other judges who are set up called a fire brigade. And what they do is they go to the media, and if I make a controversial decision, they will go to the media and they will say, what Judge Ehrlich was doing was looking at this law. The law pre-existed him, it's precedent, it's his responsibility to follow that law, whether he likes the law or doesn't like the law. So essentially, the role of the fire brigade is to educate the public on why judges make decisions in the manner that they do. Does anyone here know if their jurisdiction has anything like this, like a fire brigade, who talks to the media? You do? Okay. So you have someone in your court. Okay. This is like a chief judge or presiding judge.
We call it judge speaker.
Judge speaker.
Yeah.
Let me suggest to you that this be one of the takeaways that you might want to take away from this session, which is that if you don't have the fire brigade or a public information officer or someone there to speak on behalf of your judges, you might want to consider that. It is a wonderful tool to, again, enhance public confidence and trust in the judiciary by educating them on how and why judges make their decisions. The judges making those decisions are usually, at least in our jurisdictions, hamstrung from defending ourselves. And therefore, it's really important for somebody to be there to defend us in terms of what we do on a daily basis. So again, we have, and this is going to go to the heart of what we're going to talk about in procedural fairness, but a judge shall be patient, dignified, and courteous to litigants, jurors, etc., and shall require similar conduct of lawyers and staff. So similarly, not just decisions by judges, but misconduct and bad behavior also undermines the confidence in the judicial system. All of these rules under the ABA that I've shown you have the same goal: ensuring fairness in the proceedings and impartiality in the outcome of those proceedings. So what do I want to teach you this afternoon, or train you, I guess is the operative word here? What are our learning objectives? Procedural fairness, it develops from empirical research. It's evidence-based. And it shows that how cases are handled has an important influence upon people's evaluation of their experience in the court system. Studies and experience show that increased trust in the system increases compliance with court orders and greater acceptance of the court's authority. This is really a key element that I would like you to take away today as well. And that is that, and you're going to see me repeat this often, I'm going to show you studies that validate this principle. And the principle is this: if public trust the courts, if public trust the procedure in which their cases are handled, they are much more likely to comply with the judge's decision and respect the court and respect authority of decision makers in general. And so I'm going to talk about how procedural fairness works and then some practical information on how it is applied. So another theme we have is, this is the little cat looking in and looks back and sees the lion. Judges don't see things the way everyone else does. It's not surprising. Judges, unlike the public, are trained in the law, and we're often cloistered over time. Where do I spend my time? Mostly in my courtroom or in my chambers. So I see things differently. And it's critical for me to take that mirror once in a while and turn it around and see how the public sees me and sees the judges in my court. And there are a number of ways of doing it. We talk about the fact that I used to have a videotaped courtroom, and that's one method for seeing how you come across to the public as a judge. So how do judges look at it? Well, we know that the United States Supreme Court can declare an act of Congress unconstitutional. But the public, 45% of the public, don't get that right. So this is a basic understanding of every judge who's in a courtroom, and yet the public is not very well educated on this very basic principle that we take as a given when we make our decisions. There's lots of studies like this. Essentially, these results show this result and also United States Supreme Court approval. It fluctuates over time. It depends on the most recent decision. So if there's a controversial decision made, for example, the law which upheld Obamacare, a lot of people who didn't like Obamacare aren't going to have trust in the United States Supreme Court. There was another decision called Hobby Lobby, which dealt with whether private companies could deny medical coverage or health coverage for certain types of procedures based on religious beliefs. Supreme Court said 5-4 that they could. Again, another controversial decision. So the trust in our highest court often depends on the most recent decision that they made and whether or not you agree with that decision. So let's look at other countries. So this is an overview chart of international variations. You can see some significant regional differences. Interestingly, the highest compliance is in Asia. The regional confidence in the judicial systems and its courts are highest in Asia. Next is Europe, Sub-Saharan Africa. North America are very close. Latin America is lower, and then the lowest is the former Soviet Union. And it doesn't say anything about the Eastern Bloc, but I think that may be similar with some of the Eastern Bloc countries. Why? I think there's many explanations, and they probably vary from region. And they may because in some countries, particularly, for example, in Eastern Europe and parts of Latin America, we have developing democratic institutions. Other countries, they face significant corruption in the judiciary, which gets publicized. In my own country, criticism from external forces, which is our U.S. experience, and very relevant to what we're doing at this conference, is a lack of training and education for judges. And also public perception of the judiciary, which is promoted in the media. So this information is actually in your materials. I'm not going to go country through country. I think the Philippines is pretty good here. 61% confidence in your court system. So that's pretty high, higher than in the United States. So you must be doing something right. So this public confidence is fairly high. Again, you might want to look at your own country. Confidence in former Soviet Union is quite low. Let's look for my friend from the Ukraine. 16% confidence in the judicial system there. Latin America, wide variation. Uruguay and Mexico are fairly high, Costa Rica fairly high, and then we get down to Peru, Paraguay, and Chile. We heard from one of our colleagues from Chile present yesterday about some of the systems that they are using there to promote democratic institutions and enhancing education for their judges. These are state court systems that were taken by Gallup, that is a national polling company in the United States. Again, the numbers are fair. Very well and well, fair and impartial, 57%, provides equal justice to all, 54%, provides good customer service to people, 44%. So the numbers are okay, they are not great. So this is a rather concerning view, which is that the public believes, 30%, to a great extent, a judge's ruling is influenced by his or her personal political views. To a moderate extent, 45%. This is kind of a glass half empty, glass half full. A large number of the public believe that judicial decision-making is influenced by factors other than impartial or independent analysis. This is something that we in the United States, and I think all of us as judges, judicial educators, need to educate the public on. That we don't make political decisions, that we need people to go out there and explain why our decisions come out the way they do, and it's not for political reasons. Another statistic shows to what extent do you think that a judge's desire to go up to a higher level influences the decision of that judge in making a decision? Again, the numbers are not particularly encouraging, 35% a great extent and 40% a moderate extent. Now, as discouraging as some of these numbers may be, this isn't nearly as bad as looking at the press and Congress, which typically hover down around 4 to 6%. What about other professions? Well, the good news is we're above auto mechanics and newspapers reporters, but we're below grade school teachers and police officers. So we're kind of smack in the middle in terms of honesty and ethical standards of judges. We might think that judges should be at the top of the list. I mean, we are there to enforce the law, and we should have the highest ethical standards. So it's a little bit concerning that we are in the middle of the pack. Let's get right down to procedural fairness. What are the factors that have been studied that contribute to perceptions of fairness? Perceptions of fairness. 3 factors that we're going to look at are outcome favorability. What is outcome favorability? That means, did I win? If someone wins their case, they're less concerned about whether the procedure was fair or not. Outcome fairness. Outcome fairness means I may not have won, but at least I feel as though I got heard and the judge was fair to me. I got what I deserve. And then procedural fairness was, for both sides, or all sides, was the procedure that was used in the courtroom fair? Was it a fair procedure? When we talk about outcome fairness, as a trial judge, one of the greatest compliments I ever got was serendipitous. I was at a restaurant one evening, and I was getting ready to leave, and this gentleman comes up to me, and he says, "Judge Ehrlich, you may not remember me, but I had a case in your courtroom, and it was a such and such case." And as soon as he said it, I remembered the case. He said, "I want to let you know something." I said, "Okay, this could go either way." He said, "I lost the case, but I think you were very fair to me." And I think that of all the positive feedback that I've received in my 17 years on the bench, that was one of the greatest compliments I've ever received. I don't think as a judge that we can ask for more from parties and from litigants and from the public. You know, I don't need for somebody to, "Oh, that was a great decision you made." You know, I mean, maybe I put a lot of work into it, maybe the analysis was good, but I was really doing my job. But when someone says, "Judge, I got a fair shake in your courtroom even though I lost," that's the greatest compliment that one can receive as a judge. And that, to me, is the goal that all of us should be pursuing as judges, as educators, and as people who work with the judicial system. Again, statistics that show wide variation in confidence in state courts. There's a lack of trust in institutions as a whole, not just courts. So courts can get dragged down in general by institutions. Remember I told you in our country, Congress and the media hovers around 4 to 6%. Our president right now is about 38, 39%. So these are established institutions, and the judicial system is just another one of those established institutions. There, in many, many countries around this world, there are strong feelings of anti-institution, anti-establishment. We see it in Britain with Brexit. We see it in the United States with our president. We see it internationally. And so what we need to do is try to work with our judiciary to stay above the fray, if you will, to not engage in the colloquy with those who criticize us, who go out and educate the media on what our role is, why we make decisions in the manner that we do. So the good news is, at least in our state courts in America, people find that judges are well qualified. They find in general judges are honest, that they defend the people's rights, and that courts treat people with dignity and respect. The bad news is, so some goals of the judicial system. First and foremost, we do justice. That's what we do. We come to the right decision, we do justice. And we also can handle cases that lead people to accept and abide by our decisions, and even retain and enhance the trust and faith in our justice systems. So, procedural fairness, I'm going to find my notes here, sorry. So procedural fairness shapes the public's perception of the judiciary. A fair treatment reinforces the institutional belonging and well-being that feeds social obedience to authorities. Again, going back to my earlier theme, people trust the system, people feel as though they were treated fairly, they're more likely to comply with court orders and with other authorities. one key factor in determining compliance is trust and belief in the system and procedural fairness. So again, to go back to the earlier chart, we look at outcome favorability, one factor. Did I win? Outcome fairness, did I get what I deserved? Procedural fairness, was my case handled fairly? So interestingly, lawyers and the public have very different views on procedural fairness. There's an interesting twist to the surveys and analyses that are revealed. Unlike the general public, lawyers and assumedly judges give more weight to outcomes than to process. And that's what this chart shows. So we look at attorneys, oh, you can't see it. Let's see, lawyers are here on procedures and outcomes are here. Basically reverse this for lawyers. Oh, okay, thank you. Yeah, I don't know why it's not showing up there. Thank you very much. Okay, so we see a flip. So lawyers put a lot more weight on outcomes, and the public, the litigants, the people who actually show up in court, represented by lawyers often, put more weight onto procedures. So what is that all about? Well, lawyers are more attentive to who wins or loses. Their clients might feel differently about paying them, depending on whether they win or lose, than to procedural fairness criteria. Second, when procedural fairness is considered to a certain degree, this is true for all races and demographics. So the public, regardless of race, demographic meaning age or gender, this crosses all races and demography. Third, and most importantly, this provides insight into what we can do to raise public confidence. The most productive avenues are in the courthouse itself. The basic message is that when people come into our courtrooms and into our courthouse, we must do as much as possible to promote fairness. And remember, we're not just doing it for the two attorneys and the two parties in our courtroom. We're doing it for every spectator in our courtroom. For everybody who comes into my courtroom and observes, if they see me yelling at an attorney, if they see me, the witness on the stand, and I'm watching my computer, then I am disengaged. And people are going to feel as though they didn't get a fair result because I was not engaged procedurally. And this is true in terms of predicting confidence, whether people have prior courtroom experience or no courtroom experience. Procedural fairness is the best predictor we have as to how much confidence people have in our courts, the fairness of their encounter with our judges, and the likelihood that they will comply with court orders. And this shows different views depending upon whether people have prior courtroom experience or no courtroom experience. As you'll note, if people have courtroom experience, again, the most important factor in their experience is procedural fairness, and then outcome fairness, efficiency, and cost. If they don't have any courtroom experience, it's still procedural fairness, but they put a greater weight on efficiency. Why is that? If people have never been to court before, they don't realize how inefficient we are. If they've been to court before, they know there's a lot of waiting around, there's a lot of downtime, they have a greater expectation of the pace at which the court is going to go. But nonetheless, regardless of experienced court litigants or inexperienced court litigants, they put the greatest weight on procedural fairness. So, what is the meaning of procedural fairness? We have a number of factors here. Outcome favorability. Did I win? Outcome fairness. Did I get a fair shake? Was I treated fairly? Was the outcome that I got the right result? In other words, people sometimes go to court knowing they have a weak case. They think they might lose, they lose, and they say, that's okay, I know it was a long shot, the result was fair. But look at this, the other aspects of procedural fairness that are on this chart are voice, respect, neutrality, and trust. All of those greatly outweigh outcomes. Outcome fairness or outcome favorability. Now, I'm not saying that people like to lose. Nobody likes to lose. But people accept losing and accept the decision of the court if they feel that the procedure has been fair. They accept losing more if the process has been fair. And most importantly, as judges, and I mentioned the fact that sometimes we need to defend very unpopular decisions, and yet people will accept those unpopular decisions if they feel as though the process was fair, if they feel as though they were heard, if they feel as though they were respected, and if the judge explains how and why he or she reached that decision, people will walk away much more willing to accept that decision and comply with what the court has ordered. And this is very important because as judges we're in a bit of a cocoon. We have to cloister ourselves from public criticism. And this is very important to do because I would like you to all think about something, particularly any of you who are judges or work with judges. Judges are the only government officials, the only public officials, whether we are elected, as I am, or appointed, as my colleague is, who are not given our positions to carry out the popular will. Think about that for just a moment. So it's even more difficult when you elect judges. So in America, we elect everybody. We elect the tax collector, we elect the garbage collector, we elect the mayors, the city council, the governors. Everybody gets elected, including judges. And what people don't understand, and this again goes to education, is I've hired you as my judge, Judge Ehrlich. You should make a decision that I want you to make. Because that's the way that all other elected officials are supposed to respond to their constituents. So elected officials, if they make an unpopular ruling or unpopular decision, then they either have to change the decision because their constituents say we don't want you to vote that way, or they're going to get voted out of office. Judges don't do that. We are duty bound to make unpopular decisions. And that's actually reflected in this ABA Rule 2.4. That we must make our decisions regardless of any potential public clamor or criticism. The concepts and principles of procedure fairness apply across the board. It doesn't matter if there's a lot of money involved. It doesn't matter if there are emotional issues involved, like child custody. It doesn't matter if there are moral or political decisions involved. People are always looking at the process, and procedural fairness will always outweigh the outcome of the case and outcome desirability. As I mentioned earlier, they don't fade. It applies demographically to all ethnic groups, income, education levels, and across genders. So what are our aspects of procedural fairness? First, we have respectful and dignified treatment of litigants. I don't know how many of you attended Judge Kent's presentation yesterday. She's the Supreme Court Justice from Canada, but she had a very poignant example of a provincial judge who made very, very highly inappropriate and disrespectful comments about a sexual assault victim, and how that the media covered that case, and eventually that judge had to resign. And so one of the key components of procedural fairness is respectful and dignified treatment of litigants. All roads, all of these items, whether it's providing explanations, treating people with respect, all of these lead to the legitimacy of the courts. It leads to its enhancing its authority and ultimately complying with our decisions. This is one of the most interesting studies that I like, and that is that they did brain scans, and they showed, we all know that people react to chocolate. It sets off, I don't remember whether it's serotonin or one of those synapses, one of those enzymes in your brain. We all know what chocolate does to many of us. We all know what a smiling face does to us. But they also get the same reaction in brain scans from perceived fairness. It's really, you know, we had a big discussion yesterday about should the word be training or the word be education. And many of us felt, well, training is for dogs and education is for judges. But when you come down to it, the bottom line, I can talk about procedural fairness and treating people with respect. It's customer service. It's really customer service, because what we are is we are public servants. And if we're treating people as though we want them to come back to our place of business and feel safe and feel as though they're going to be treated well, that's procedural fairness. And that's what's going to make them feel positive about our court system. Sometimes I think of ourselves as missionaries, because every time so we have a jury system. And when I deal with jurors, I usually have 50 or 60 in my courtroom before we pick the actual jurors who are going to sit on the case. I know many of you don't have the jury system. But I think of myself as a missionary. I think of myself as every single person who comes into my courtroom and has a positive experience is going to go out in the real world and they're going to say, you know, I was in court and I was treated very respectfully. Or the judge really explained things to me. You know, it's not like you see on TV. And that's what we really need to do. It's partly about educating judges, but it's also about educating the judges to educate the public as well. And this is a very, very important slide as well. Again, the strongest factor in determining how people feel about a decision and about the judge is whether the party received fair procedures. And you'll note that acceptance of court decisions might be, did I win? Or it might be, I got what I deserved. But that's greatly outweighed of, I had my day in court. I'm going to go for about another 15 minutes, and then we're going to take a recess. So I want to talk with the first principle, which is the principle of voice. People want to be heard, but it's different than what you think. So it's not just I sit there blank-faced and the person just talks and I say, okay, you've said what you had to say, now I'm going to rule. It's what's called active listening. And what it means is I'm not just listening, but I'm letting that litigant or that attorney who was ever in my courtroom know that I've heard what they have to say. Did you have a question you want to ask? Yeah, that's fine. Sure, no, please.
Sir, I have a question. So far that what I have understood is that how to gain public trust through procedural fairness
Yes.
in the courts.
Yes.
Maybe this problem pertains to Pakistan, and that is why I'm putting this suggestion. I don't know whether this problem pertains to other countries as well. The time taken in the decision of cases.
Yes, absolutely.
This is a very big problem back home.
Yeah.
And that is playing a major part in eroding the public confidence in the system. Because if a case is instituted in my lifetime, that would be decided in my son's lifetime. So that is something I think which should be covered in this, how to get public confidence, is to decide cases expeditiously. Thank you, sir.
That's a superb point. And although it doesn't necessarily go directly to the procedure, but I will say in my jurisdiction under our Constitution, a trial judge has to make his or her decision within 90 days. If we don't do it within 90 days, then there can be ramifications of either our not being paid, or we can be disciplined by the Conduct Commission. And that's something, I'm glad you brought that up, because it's something that in those jurisdictions that don't have those guidelines, you might consider, one, establishing guidelines or establishing rules, and the consequences of violating that rule. But, you know, there's the old adage of justice delayed is justice denied. And people, judges, again, we're a little cloistered, so we forget sometimes that when they bring that case into our courtroom and that we have to decide who the young kid is going to live with, who this son or the daughter is going to live with, that directly affects those people's lives, and we need to make those decisions on a timely basis. So thank you for bringing that up. Another aspect of procedural fairness is that shift that some of you don't have in your jurisdictions, but in Anglo-American law, typically people go from being a lawyer or a barrister to becoming a judge. And so what judges have to remember is that part of procedural fairness is that we're not an advocate. That's a very difficult role to change. So for 20 years, I advocated. I was a private attorney and I defended lawyers. And I knew my rules of evidence, I knew my way around a courtroom, and so now I'm the judge in the courtroom and I have a weak lawyer in there. And what I want to do is I want to say, object, or ask it this way, and you really have to shift. And so it goes to the issue of neutrality, which is judges, in particular those who came from an advocacy role, need to reminded and practice that your role is that of a neutral fact finder, of a neutral decision maker. And I have a Socrates quote on there. Again, so Socrates, this is from, quoting from Socrates. And I want you to just note, and my history isn't that great, what are we talking about, maybe 2,500 years or so ago, Socrates, 3,000? He had procedural fairness down. 4 things belong to a judge: to hear courteously, to answer wisely, to consider soberly, and to decide impartially. So, you know, sometimes, as the French say, la plus ça change, le plus le même. The more things change, the more they remain the same. The 4 components of procedural fairness: voice, neutrality, respect, and trust. Voice. This is the ability of a litigant, of a person coming into a courtroom, to participate in a case by expressing their viewpoint. And we have to ask, how are we going to do that? One is formal participation. Mr. Plaintiff, you have the opportunity to explain to me what you believe happened here. Giving them the voice so that they know that they have an opportunity to be heard. This could be very difficult. Here's the conflict. This isn't necessarily true in my courtroom because I'm a court of general jurisdiction. We typically only hear one trial at a time, and then I might have 1 or 2 other hearings. But there are some courts that have 20 or 30 cases on their docket. And so the balance is this. You want to give people an opportunity to be heard. You want them to have the perception and the belief that they've been heard, and you want to run an efficient courtroom. And that's the conflict and the balance that so many judges face. I don't generally face it, again, because it's the nature of our caseload, which is quite different than a court of limited jurisdiction. But if you're hearing traffic cases or smaller misdemeanor criminal cases, and so you need to fashion a manner in which those people can come into your courtroom, have that time, know they've been heard, and then make your decision. And one of the most difficult things for judges is, sometimes I've read the paperwork, I know exactly how I'm going to rule, and I could be very efficient if they come in and say, I've read the papers, I'm denying the motion. But if I do that, the person who loses is going to walk out of there and say, why did the judge do that? He didn't even give me an opportunity to be heard. The other thing a judge can do sometimes is ask open-ended questions if they want things further explained. So voice is very important. Neutrality is also very important. What do people want? What do litigants want? They want a neutral, principled decision maker who bases decisions on rules. Not on their personal opinions or political beliefs, but on rules, and apply those rules consistently across all people and over time. They want a neutral playing field. This principle, of course, goes back to Bangalore, and it goes back to the basic rule of law. Consistency in rulemaking and predictability in decision-making. Litigants bring their problems into our courtroom because they do view judges as neutral. We need to be transparent about the way that we deliver our decisions. We need to explain them in terms that are understandable. You know, the problem is that I need to shift sometimes because I'm talking to lawyers a lot of time during the day, and all of a sudden I have somebody who's representing him or herself, and I need to explain things to him or her in a way that they can understand that's not in legal mumbo-jumbo. The other thing is, when I issue an order, I know the lawyer may be explaining what my order is to the litigant, but I think it's just as important for them to hear it from me. This is what I'm requiring you to do. I'm requiring that you go out and that you get a drug and alcohol evaluation, you complete that evaluation, and you follow all recommended treatment. And if you don't do that, here are the consequences. It comes across as very differently when the judge is telling them this, rather than the lawyer sitting them down and saying, yeah, the judge wants you to do this, you're going to have to do it. It's really quite a very different experience. And also to cite the reasons that I'm ordering this. What I often say is, sir, I'm not sure if you have a drug problem, but I've reviewed the record, and what I see in the record indicates to me that there might be an issue here. So what I want to do is rule it out. I want to make sure that there isn't a drug problem, but if there is a drug problem, and that's the reason you're committing these crimes, I want to keep you from coming back to my courtroom, because that's really my job, is to keep you out of the system. And I explain all that to them, and they kind of, I don't know how successful it always is, but at least they can understand that I'm not just arbitrarily saying, go get drug treatment, go get evaluated. Respect. One of the biggest points that I want to point out here is nonverbal cues. And I had the very fortunate or very unfortunate experience, depending on your perspective, of my very first courtroom was videotaped. So I didn't have a court reporter. Now it's all digitally recorded. But it was videotaped. And someone made a suggestion to me, a recommendation, that I go look at myself on the tape. And it was one of the most painful experiences that I've ever had in my professional life. I thought I was being a good listener. I thought I was being patient. And I watched these tapes. I was impatient. I cut people off. And I didn't even know I was doing it. And one of the best tools that a judge can have, not just on how he or she is expressing themselves, but also on what are their nonverbal cues. And right now we have so many distractions and so many other temptations, which is the computer on the desk, and I'm getting email messages, and I might be distracted and wanting to look at the email message. In the meantime, the lawyer wants to talk to me, or the witness is on the stand. And what the litigant is thinking is, Judge, you're making a decision and you didn't even listen to my case. And so what I do is I explain that from time to time I will need to get on the computer. I'll make sure that if it's distracting me, I'll let you know and we'll stop the proceedings. Because there are times I have to get on the computer. Showing respect to everybody in the courtroom. What we have to understand, again, I want to reiterate, it's not just the two people in the courtroom that have their case. It's all of the rest of you that are waiting for your cases or just watching me to observe a court proceeding. People, come to court because they have faith in us. Think about what they're doing. 5,000 years ago or 10,000 years ago, they would just grab their hammer or their club and take justice into their own hands. But instead what they're doing is they're walking into our courtrooms and they're saying, I'm going to put this issue, which is important enough to me to take time out from my life and pay money to come down here, so that you, who I don't even know, are going to make a decision affecting me. That is such an incredible responsibility and privilege that we have as judges and those involved in the judicial system. Again, if what I do, and I've been very lucky, I hear my colleagues say, oh, they had lawyers or parties yelling at them in the courtroom or swearing or doing all this stuff. I've never had that experience in my courtroom. And that's because even when I sentence people to life in prison, I'm always respectful for them. I always say, sir, I know this is difficult for you, but I want to wish you the best of luck in the future, and I hope your life goes well. Or something, just let them know that you can be firm, you can follow the law, and we can be a compassionate individual as well. And then again, trust. Are we listening, considering the people's views? We might be listening to their views, but if we don't tell them that, they don't know that. So sometimes I'll recap and I say, sir, what I'm hearing you saying is you believe that you had an agreement with your brother because you had this meeting and he promised you this. Let me explain to you what the law is on this. And so you need to really give evidence that you have listened and you've taken their position or into consideration. I'm going to cover the next part very quickly because we're going to recess here in just a few minutes. Judicial apologies. What this is about is, to what extent should a judge apologize for following the law? I don't think that there's anything wrong with showing basic empathy. So if somebody comes into my courtroom and they say, Judge, I know I didn't show up for my meeting with the probation officer, but my brother had died the week before and I had to go to his funeral. It's okay for me to express my empathy or sympathy for this individual. But if I'm sentencing somebody and I think it's a harsh sentence, should I criticize the legislature? Should I say, well, I think this is a bad law, but I have to follow it anyway? I think that's just the flip side of the other branches of government criticizing us. And I think what I can say is, my job, my responsibility is to follow the law. This is the law that's set out by the legislature in terms of the sentencing guidelines. I'm going to impose the minimum sentence here, but it's still 163 months. That's what I'm required to do. I think that's a fair sentence. So I think judges need to be careful on not apologizing for what the law is. Sometimes we want to apologize for societal wrong. Sometimes I'll acknowledge that somebody has had a difficult or challenging upbringing. I'll say, sir, I read your file. I recognize you had a very challenging childhood, and it's my responsibility to impose the appropriate sentence for the criminal activity that you have engaged in. Practice your listening skills, staying focused. Okay, so what can an individual judge do? This is on the PowerPoint materials that you've been provided. Just to recap, talk to people in understandable language. Teach your judges to do that. You know, I taught legal research and writing for a number of years at Seattle University as well as at Georgetown University. And the problem is this: when lawyers go to law school or judges go to judicial school, they learn to write and talk like lawyers and judges. And I read things and I would look at it, and it's such thick, dense legalese. And I would say to my students, I said, would you ever talk like this? And they say, well, of course not. Nobody talks like that. I said, well, then don't write like that. And so we need to learn how to communicate. It's a bad expression to say dumb it down, but put it in language that's understandable to the litigants. Learn how to be a better listener. There's whole courses on active listening. That's the phrase, active listening. Listening so that you're not just hearing the words, but sometimes we have to understand exactly what's going on. Sometimes it's not all about the lace curtains that they want in a divorce at all. It's that he's really mad at his wife for divorcing him. And you're never going to resolve it no matter to whom you give those lace curtains. Explain the orders to the litigants themselves rather than relying on the lawyers to do so. Again, I go over the orders that I'm issuing to the party so there's no miscommunication and no misinterpretation by the lawyers. Put something on the bench as a mental reminder that patience is a virtue. So mine is Frank Lloyd Wright. Frank Lloyd Wright was a very famous American architect. And he came out with what are called the four virtues. And it's a little glass paperweight I have with the four virtues. And they are: love is the virtue of the heart, sincerity is the virtue of the mind, decision is the virtue of the will, and courage is the virtue of the spirit. And whenever I have a difficult decision, I look down at my little paperweight, I look at those virtues, and it emboldens me and gives me courage to do the right thing. At the start of a docket, the docket meaning the judge has a lot of cases, explain what the procedure is. So explain to everybody what their expectation is. Everybody gets 5 minutes. It doesn't matter whether you're a plaintiff or defendant, a lawyer or non-lawyer. Explain if you're setting lawyers first. Sometimes people think, oh, you know, we had an example of the judge at the medical appointment yesterday in my session, and should the judge be allowed to go to the front of the line because he's got a big docket in the afternoon and he needs to get through his medical appointment. Well, if I allow attorneys on a busy docket to come first, which I might do, I will explain the reason we let the attorneys go first is because when they're finished in my courtroom, they need to go to another courtroom. And we're not giving them preferential treatment, we're just explaining why we do this procedure. I talked about videotaping. I think it is an invaluable process for any judge to learn how we come across. Enlist our local training institutes to assist us on how we present ourselves. Are we being impatient? Are we being rude? Are we being bad listeners? Are we being distracted? And then lastly, I always thank people for being there in the courtroom, for serving as jurors, and for their patience. We are going to have an opportunity after the judge's presentation for general discussion, any questions that you may have. But I wanted to thank you all for listening to me actively this afternoon.
Thank you, Judge Ehrlich, for that exhaustive and very informative lecture. It's an unholy hour of the day. So we will give you 15 minutes break. You can have your snack outside, and session will resume at 3:05. Thank you. Please welcome your next speaker.
Good afternoon. Mine is not really a lecture. This will be more like a response, a reaction to the very comprehensive lecture that we just had from the Honorable Judge John Ehrlich, which I am very privileged, I'm very privileged to have met since yesterday. So when I first heard the term procedural fairness as a topic for this conference, my first instinct as a lawyer, knee-jerk reaction, as a judge, was to look at jurisprudence to find out how the term is defined and used in cases decided by the Philippine Supreme Court. Surprisingly, I found the term procedural fairness used by the Supreme Court in close association or equivalence to procedural due process. In the case of spouses from Waldes versus Comelec, Justice Tinga, in his dissenting opinion, stated very generally, substantive due process guarantees against the arbitrary exercise of state power, while procedural due process is a guarantee of procedural fairness. In the concurring opinion in People of the Philippines versus Panfilo Lacson, Justice Bellosillo stated that procedural fairness required by due process decrees the dismissal of an indictment if it be shown that delay caused substantial prejudice to the rights of an accused to a fair trial and that the delay was an intentional device to gain tactical advantage over the accused. In Perez and Doria versus Philippine Telegraph and Telephone Company, the court said, at its most basic, procedural due process is about fairness in the mode of procedure to be followed. This is not a novel concept, but one that traces its roots in the common law principle of natural justice. Natural justice connotes the requirement that administrative tribunals, when reaching a decision, must do so with procedural fairness. So going beyond traditional case law, I decided to consult the almighty Google. And I looked at the words procedural fairness, Googled it, and found several articles, studies, writings that resonated with what I had been feeling and thinking about as a prosecutor for 8 years and as a judge for the past 7 years. I had often wondered whether my work as a judge in a special drugs court really does contribute to solving the drug problems in our society. I had often asked myself to what extent is the court system helpful in resolving the ills of society, the disputes between family members and competing claims of parties? So I took a look at the seminars and trainings that I have undergone as a judge, and I realized the focus and substance of most of these trainings were on laws, implementing rules, procedural rules, decisions of the Supreme Court, interpreting the laws, latest updates and developments of laws. Yes, we have been taught, and we are continually being taught, how to decide cases and how to apply laws to specific situations that we need to resolve. But I have yet to participate in a forum to seriously discuss the effects of what we do as court workers vis-a-vis our role as dispensers of justice. I have yet to learn about a locally done research analyzing the impact of our work on the people who come to our courts, whether voluntarily or involuntarily. That is why I really appreciate the lecture of Judge John regarding the researches that have been made in the United States. I have noticed likewise that in the evaluation of our work as judges, the emphasis is on disposition rates, compliance with prescribed periods for resolving motions and deciding cases, compliance with reportorial requirements and the like. The emphasis on these measures, of course, is understandable, considering the persistent and nagging critique against the Philippine courts as very slow. We are continually reminded of the adage that justice delayed is justice denied. So we are asked to move and to move faster. We cannot, of course, disregard and overlook the local context. The fact that many of our courts are clogged with voluminous caseloads, beset with the lack of prosecutors and public attorneys, and constantly understaffed. This notwithstanding, I believe that our trainings on legal matters, without a concern for how our court workers, judges, and staff deal with and relate with the public, without looking at behaviors that matter, may be counterproductive. How do we make judges more effective decision makers? How do we improve compliance with court orders? How do we increase public satisfaction with the court system? These are legitimate questions that require going beyond discussion of laws and procedural rules. These are issues that necessitate a re-examination of our present measures of success. These are concerns that ultimately would entail a re-evaluation of judicial training. It is against this background and my experience as a judge of the Regional Trial Court in the southern city of Cagayan de Oro in Mindanao of the Philippines that I am excited about, and I welcome the growing movement towards the attainment of procedural fairness in courts around the world. I was especially inspired and moved when I learned from my readings that in Alaska, it's thousands of miles away from my country, every courthouse has a poster announcing its Pledge of Fairness. And that Pledge of Fairness is translated into 6 languages, including Tagalog, our language. The Alaskan Court's Pledge of Fairness states as follows. The fundamental mission of the Alaska court system is to provide a fair and impartial forum for the resolution of disputes according to the rule of law. Fairness includes the opportunity to be heard, its voice, the chance to have the court process explained, and the right to be treated with respect. The judges and staff of the Alaska court system therefore make the following pledge to each litigant, defendant, victim, witness, juror, and person involved in a court proceeding. We will listen to you. We will respond to your questions about court procedure. We will treat you with respect. I wonder how that sounds in Tagalog. If you are a Filipino out there, away from your family, and here you are facing a courtroom and there's this Pledge of Fairness talking to you in your own language. This Pledge of Fairness for me best encapsulates the principles of procedural fairness in simple, straightforward language. From a reading of several articles about procedural fairness, I have learned and realized that procedural fairness is not just about following rules of procedure. It's not just about rules, the implementation and interpretation of the rules. It is concerned about the effect of our decisions, procedures, and processes on the people who come to our courts. It is concerned about how the public perceives the court processes to be. It is concerned about whether the public finds the court processes to be fair. As explained by Emily Gold, Lagrata, and Phil Bowen, they said that when courts act with fairness, people are more likely to respect the law. But it's not enough for courts to simply act impartially. They must be seen to be fair. And counterintuitively, research has shown that being seen to be fair is less about the decisions, as explained by Judge Chan, about the outcome that courts take, and more about the way that they take them. Experts often refer to these as procedural fairness, the fairness of the court's procedures and practices. The research has shown, so this is really evidence-based, that if courts are respectful, neutral, easy to understand, and give people involved in the case a voice, they can build trust in the law. It is this trust which causes people to comply with court orders, to cooperate with the police, and ultimately to obey the law. Again, Emily Gold further described procedural justice as the idea that how individuals regard the justice system is tied more to the perceived fairness of the process and how they were treated rather than to the perceived fairness of the outcome. I will just go through the 4 principles, although it has already been extensively discussed by Judge Chan. The elements and principles of procedural justice and fairness are voice, litigants' ability to participate in the case by expressing their viewpoint, because people want to be heard. Neutrality. This is consistently applied legal principles, unbiased decision makers, and the transparency about how decisions are made. Respect. Individuals are treated with dignity and their rights are explicitly protected. and trust. Authorities are benevolent, caring, and sincerely trying to help the litigants. A trust garnered by listening to individuals and by explaining or justifying decisions that address the litigants' needs. In other words, people believe a process to be fair if they are, first, they are given the opportunity to be heard. Second, if they perceive that the decisions are made in an unbiased and trustworthy manner. Third, if they feel that they are treated with dignity and respect. If they understand how decisions are made and what is expected of them. And if they feel that court personnel are caring and sincerely trying to help the litigants. So voice, neutrality, respect, and trust. These principles seem very simple and sensible, yet may be difficult to achieve unless judges and court personnel are prepared to adopt new attitudes, expand certain perspectives, and develop appropriate skills. It is certainly challenging considering that court workers are accustomed to looking at court work in terms of tasks to be done, cases to be disposed, deadlines to meet, and reports to submit. That's our daily task. It would be tough for judges who are used to treating their job as a position of power and privilege rather than as a mission to serve, to be of service. How can the litigants have the opportunity to be heard if they are totally oblivious to what judges and lawyers are talking about, usually in a foreign language? For our jurisdiction, it's English. That sounds like gibberish because of the penchant of lawyers for mouthing legalese. How can litigants be encouraged to voice out their opinions when they are relegated to the background because of the tendency and general practice of letting the lawyers alone do the talking? In my court, for example, I am in a regional trial court. The people there speak Visayan. I can speak and I understand Visayan. But when we are in the courtroom, we have a translator. The witness will speak in the Visayan. The translator will translate it into English. And then the prosecutor, for example, will ask him again. The prosecutor will ask him in English, and the translator will translate it to Visayan. When in fact, I can understand him perfectly in the Visayan, and he can understand me if I speak in the Visayan. But we have to go through this process of translation. It's really weird. So, of course, there's filters, right? If you look at our records, you'll find out that especially if you have lawyers that are not really very good in English, or you have translators who are not good in English, you have very poor records. Second, to be perceived as neutral, judges need to be trained not just about procedural rules, but about basic communication principles. Judges and court staff need to develop an awareness of what their behavior projects to the public. For the public to feel that they are treated with respect and dignity, judges and court staff need to learn clear and respectful communication, among others. And for the courts to gain the trust of the public, judges and court staff need to learn how to listen sincerely and actively, as Judge John said, and how to explain procedures patiently. Indeed, the task ahead might be tricky and daunting, as this initially requires an openness to receive feedback about the work that we do, and judges don't usually like feedbacks. So, what do I suggest as ways forward? This is where judicial training comes in, to help build awareness about the principles of procedural fairness, to help inform judges and court personnel about the benefits and the positive outcome of practicing procedural fairness, and finally, to help develop strategies and enhance skills. From where I stand, I can imagine some possible action points that can be explored and tried. For example, we can encourage local research surveys to identify the public sentiments and views about the court system. We can develop partnerships with academic institutions. In Cagayan de Oro, the city where I come from, there is a growing number of criminology and law students who do court observations frequently. They can be tapped to provide feedback on courtroom behavior of judges and court personnel. We can maximize bench bar dialogues by introducing the concept and principles of procedural fairness as measures for evaluating court processes by the private lawyers. Of course, we can have trainings on procedural fairness for judges and court personnel. Then we can reach out and influence the other agencies of government involved in criminal justice, such as the law enforcement and prosecution, through roundtable discussions and joint trainings on procedural fairness. And finally, we can have peer-to-peer sharing of best practices among courts locally and internationally. These may be small baby steps, but they are worth a try as we seek to convince judges and court staff that ultimately focusing on procedural fairness is an empowering movement for the court system, as it should lead courts and judges towards better performance, better outcomes, and greater public approval. Thank you very much. Good afternoon.
Thank you, Judge, for that very enlightening lecture. We will now go to the open forum. There is no need for me to repeat the rules, but I suggest that if you want to ask an oral question, you take the microphone in the middle of the aisle, and then you can also ask questions in writing. You know, you should be informed that we have 7,100 islands in the Philippines. And when Judge Corazon Laderal said that we have difficulty in communicating with our litigants, it's because we have 75 dialects. And so we have to appoint in every court one who is proficient in that dialect. And this has to be translated in that dialect, in Tagalog, and also in English. And that's why we have a problem of delay in the administration of justice. So the table is now open for any question that you may ask on our speakers. Please state your name and in particular the speaker whom you desire to give you the answer. It appears that yes. I thought everybody knows already what is contained in the lecture. Okay, you are recognized. Please state your name.
Good afternoon, Justice. I am Judge Soliman Santos Jr., RTC, Branch 61, Naga City, Philippines. The question is addressed to both Judge John and Judge Ason, for short. It's about the challenge, one particular challenge mentioned by Ason, which I also encounter often in my own court. About lawyers being the only ones doing the speaking, no? The voice that is heard is only that of the lawyer. It's become the practice, the tradition, and oftentimes when the client or litigant would try to say something, the lawyer immediately stops him. No? So how can we handle that kind of a situation? Is it through a bench bar dialogue or some other ways? Thank you.
Judge Ehrlich.
That's a wonderful question. That's also universal. I think that there are probably a number of factors in play in a lawyer telling his or her client, that's okay, don't say anything. In the criminal context, there may be a lot of reasons that the lawyer does not want the client to speak. Because the client could easily say something to implicate him or herself with the pending matter, which of course the lawyer wants to avoid. And many of these clients aren't sophisticated. The lawyer, they don't understand the burden of proof on the state to prove all the elements of the crime. And so the client sort of often wants to sort of jump in there and say, well, I didn't intend to do this, or it got out of hand, or something like that, which is very inculpatory. So in the criminal context, that's one situation. In the civil context, it depends on the type of hearing. So in certain hearings, if it's a summary hearing, it may just be a strictly legal matter. It may not be appropriate, even if the client is there to speak. So I think the judge has to consider the specific situation and whether it would be appropriate for the client to speak. I often will be in a situation where I'll simply ask the lawyer, would your client like to say anything to the court? And so that way I don't jump over the lawyer's control of the client, but I also afford the client the opportunity to speak if the lawyer is okay with that. And I'm very conscientious of that when it comes to criminal cases.
I agree with Judge John. I actually handle only criminal cases because my court is a special drugs court. But as for civil cases, in the Philippines, we are now developing the court mediation and judicial dispute resolution, which I think is part of that process of trying to get people to be heard in the case that they are involved in. So, yeah, I think that's one way of promoting procedural fairness and but through alternative dispute resolution and processes.
Other questions? Please.
Hello, my name is Una Doyle. I'm with the Judicial Commission of New South Wales in Sydney. I just had a question actually for both of you. Judge Corazon, in one of your slides, you talked about possibly how to get sort of feedback, and that's a little bit, I think, that John, in your presentation, you also said, how would we actually, the video is an ideal way, but not every court has the video. And I think you had something in there about students giving feedback, possibly. And I just wanted to ask, is that something that's encouraged, and is it working? And do you get some feedback?
Actually, I just thought about it when I was doing the research for my lecture, because we haven't had that yet. But I just remembered that in my court, every now and then we have students coming in because they want to observe court processes. So I was thinking maybe we can tap the students to, just answer a few questions so that we can have some feedback from them, because they really come to court and observe our process.
I think it's an excellent idea. I mean, I ask because we do with some of our lower courts, and when we do pre-bench training, we specifically encourage them to take part in what we call mutual observation. So they pair up with an experienced colleague and who is happy to sit at the back and make some, constructive commentary or give some about their work. So I just wondered if that was something that could be taken on board, because as you said, I think in one of the slides, you look in the mirror and you don't always see what's inside.
So I would have a couple of observations. One is, I happened to be in a courtroom that had videotape equipment for the formal record, but it doesn't have to be that. I mean, you can do something as simple as this and just ask somebody to sit there with this for half an hour during a hearing, and that's usually enough. So that's one way to do it. You don't need sophisticated videotape equipment. We also have it's usually used for younger judges, but we have usually the Bar Association provides us with 3 lawyers to come into our courtroom and observe us, and then provide candid feedback. And usually this is judges who've been on the bench for 6 to 12 months. They're fairly new. I did that, again, a relatively painful experience. It was, it was basically overall positive, but they had some very valuable constructive criticisms. So you can use the bar. It's similar to what you're saying about a colleague, but colleagues are difficult because you don't want to be overly critical of one of your colleagues. You want to encourage them. You have to deal with them for the rest of your career. Whereas you bring in lawyers then, and they're empowered to be honest and critical, that can be invaluable. So I went through that process as well. So there's a lot of tools out there. The point, I think, is whatever tool you'll use, to allow that feedback for judges and allow judges to be strong enough and courageous enough to take that feedback and change their needs.
Thank you.
Sure. Jeff?
May it please the court.
I've heard enough.
Yeah.
Motion denied.
Yeah. My name's Jeff Apperson with the National Center for State Courts. I just had some reflections that I think will generate a few comments on your part. The charts that we saw gauging, performance levels and the public's degree of trust. As I travel, I see there being different sets of values and expectations depending on the country that I'm working in regarding the expectations of performance in the judiciary. One country will accept a standard that's much lower than other countries. And I think sometimes the reason the U.S. rates, for example, may be mediocre is that our public's expectations are incredibly high. So I think those kinds of values and expectations need to be associated. The other thing that I'm really beginning to see is that global standards, such as the Bangalore Principles, are not reflective of current requirements and values. For example, and this is a really big issue that I noticed in Principle 1 of the Bangalore Principles. I'm working on the work group now that's reconsidering the principles. And that is, the principles say that the judge only has to be concerned about a fair trial. I reacted to that, and we're talking here about a fair process. So, the global standard has established an expectation in the judge's mind. If we're using those global standards, their expectation is based on the trial, where the developing trend is based on the process. And I think those kinds of trends and issues need to be considered. The other thing is this. When you talked about ways to evaluate public sentiment, my question is this, and I didn't see it up there, but I have seen this in other countries. I want to know the public's opinion immediately after the result. Why aren't we taking the surveys on the public's opinion of the process immediately after the process ends? Why are we waiting for studies or bench bar discussions? Why aren't we collecting the data as a system, evaluating that system, and anticipating the issues more quickly? That's one of the things that I considered when I was managing a court for years and years and years in our federal system is we can't manage what we don't know. And many times we don't know. And we have to wait too long to know. But I think those survey results at the public level, but especially the litigants themselves, are really important. So those are just some things I wanted to bring up.
Well, I will comment. I think those are all extraordinary observations. First of all, I think your analysis with regard to why America stands where it does in the pile is, I think you may be correct. We have higher expectations in the United States. And I think that the media and criticism is a factor, but I think our expectations are higher. And the role of judges in the common law system is often perceived very differently than the role of a judge in the civil law system. And I think that that's a huge factor, or in terms of public perception of the fairness of judges. With regard to the Bangalore principle, yeah, it's not the trial. The trial is one thing that we do. But something I didn't unfortunately have much time to talk about is it's also my staff, because litigants come in often self-representing, and they're trying to navigate the procedure. And obviously my staff can't give legal advice, but they can give them procedural advice. Where do you file something? How long does a pleading have to be? When does it due? Those types of issues. And that's a big part of perception in terms of how litigants are being treated by the court. It's actually got nothing to do with the judge, except that the judge is the leader of his or her staff. And so I am very blessed with excellent staff, because I set my expectations high for them. And they meet them. And my bailiff in particular is renowned for being especially accommodating, and people appreciate her. So I think some of the positive feedback I get as a judge is not necessarily deserved. It belongs to my staff. But I would say that the principle, the trial is one small component. There are a lot of hearings that aren't trials. There's a lot that goes on in the courtroom that has nothing to do with trials. You know, if judges have to reschedule hearings and they're not contacting litigants appropriately, and they end up spending 2 hours of their day showing up in court when the hearing's been rescheduled, that's a problem that we have in terms of fairness. So it's a very, very complex set of issues, but I think your second point is also well taken. The third point, I apparently didn't take very good notes, but it had to do... Oh, on the surveys. So we've done some variations on that. I think one of the most interesting surveys one could do is get feedback from the stakeholders, if you will, before the decision's made. So even while the jury is out, in our particular case, or before the decision is made. The biggest problem we've had, I've had some colleagues who've done informal surveys, and I've somewhat discouraged it, because I think it puts, I think if they were responding to me, that puts them in a very awkward position. But if it's blind, if I don't know who the source is, in other words, they could do a survey right after they've completed a matter in my courtroom, provide it to a third party who sits on it for a while, so I don't know it's actually that hearing, because I don't want to know when attorneys are going to appear in my courtroom again and they do have criticism, I don't want them to feel uncomfortable that somehow that's going to come back against them. So surveys can be very valuable and very tricky to ensure fairness in the future. Thanks, Jeff. Probably want another break for food.
They are waiting for your questions, please. If you are shy, write it in a piece of paper. I'll collect it from you.
We answered all their questions.
Well, apparently, this is not a part of the subject matter. This is to inform you that for your travel back to Manila, please go to the driveway of the main building for your buses. Please take the same bus you rode on your way to the lecture room. So you will not be, I hope you have not forgotten the number of your bus. They are ready to answer. If you are tired, I'll be forced to adjourn the session. And then, yes, please.
Before I pose my question, I'd just like to also make a remark to Judge John's suggestion about judicial or judges' apologies. I've also done some of that in my case, and I think it's generally fine to do. No? Judges are also human, they err sometimes, and it's fair enough to make apologies when these are due. The question is about this getting immediate feedback, especially from litigants, no? Maybe right after the process or the outcome comes out. How might that be done? What might be the mechanics of that in a way that it won't be misinterpreted one way or the other? Thank you.
So, if possible, I think you get better. It would be interesting to do the same survey, if you could do this before the outcome and after the outcome, and see if the perception on the process changes. I think it has to be done, it has to be carefully done so that it's anonymous. I think that's the only way you're going to get valid feedback from the players in a hearing. And it won't always work. I mean, if you're in a lower court, you're making decisions likely right after a hearing. So there's no gap in time. But there can be a survey form filled out. Like we evaluate our judges every 4 years, and it's actually an online survey where the lawyer certifies that he or she has appeared in my courtroom. And then they fill out and then they evaluate me. Now that doesn't give me at all feedback about a specific hearing, but the general opinion of those lawyers about how I'm performing on about a dozen different factors. You know, how quickly are my decisions made? Are my decisions properly analyzed? Was I fair to all litigants in my courtroom? Did I have proper judicial demeanor? All of those factors are in there. And that's only every 4 years. I think your court could develop a survey where the lawyers can just fill it out and provide feedback. It should be a simple survey. It could have room for suggestions for improvement for the judge, and it's done in a fashion, again, that I think has to be anonymous so that the lawyers and those appearing in court feel as though that they can be treated fairly in the future. And parties in the same way. I think feedback from parties is as valuable, if not more, than from the lawyers themselves.
I would just like to add simple feedback for me is through my staff, because they actually give me feedback also. Like, for example, if I promulgate a decision in a drugs case, if it's a conviction, etc., they give me immediate feedback about how the accused received the decision of the court. And then I also, that's why I think it's very important to really be on the same, to be able to explain this to the staff about procedural fairness, because they're at the forefront. They're the first people that people would meet when they come into the court. So it's very important the way they deal with the public. how to explain, because they're the ones that the litigants ask, Ma'am, can you explain what happened here? Because I don't know, because it's only my lawyer who is talking, etc., and we don't understand what happened. It's the chemist, etc. So it's usually that my staff that they ask, what happened? So it's very important that the staff know how to explain and to be very patient really about explaining the process to the litigants in court. So they're a form of feedback and also a form of communicating to the public. I think.
Thank you. You,
Yeah.
I see. Now, the instruction given to me here is just to moderate, but I am asking permission from the two judges if I can also ask a question.
Depends on the question.
Well, anyway, what has been extensively discussed here refers to a single sala judge. How would you consider a collegiate trial court judge? In the Philippines, we have appellate court judges. That's not a problem. But we have trial court judges in the lower level, a collegiate court. How do we go about, let's say, improving their image before the public?
So what I didn't have an opportunity to say is I also sit on the Commission on Judicial Conduct for my state, and it's the disciplinary body that reviews complaints about judges. And the vast majority of complaints come from litigants, not attorneys, and they're more focused on the lower courts or the courts of limited jurisdiction rather than my court of general jurisdiction. And I think the reason for that is the lower courts have much busier dockets. Their hearings are shorter, their dockets are longer, and they don't have the luxury often that I do, which is take a recess and bring people back the next day as necessary. So I think procedural fairness is actually more important in those courts, in what I call the people's court, because more people go through that procedure and more of them are not represented by attorneys. And so it's just the litigant and the judge. And I think what judges can do, and I tried to give some examples, but explain to them what the process is going to be that morning on the docket, what the judge expects. Let the judge explain everybody has an opportunity to be heard, but to ensure that everyone gets to be heard, he has to limit the time or she has to limit the time. So everybody gets up to 5 minutes or 10 minutes, whatever that period is, to tell me your side of the story. I will listen to your side of the story and then I will make a decision. So explaining the process, treating people consistently, let them know what to expect and give them an opportunity to be heard and let them know that they'd be heard. And again, it's that balancing that they have to do between running an efficient calendar with lots of cases and ensuring the procedural fairness components that we both discussed this afternoon. No? Nothing to add? Okay.
The second point I want to raise is about the action of a judge regarding a motion for reconsideration. How will it affect his public figure regarding the manner of disposing cases of subject to motion for reconsideration to preserve the image of the judiciary?
So, as I hear the question, how do I react to how do we as judges react to motions for reconsideration?
Yes.
I think it just depends on the basis of the motion. I just granted one because I got it wrong the first time. I didn't give the issue enough time. It was a hearsay within a hearsay issue. It was very complicated. And I listened to the case on a hearing, and it was an hour and a half long. I needed another matter, and I ruled. And One of the sides filed a motion for reconsideration. I did more research, and I concluded I was wrong the first time, and I reversed myself. I just want to get it right. So I don't take it personally. If somebody tells me, Judge, would you sign this form so my client can appeal your decision? I sign the form, and, it's to me, it's not personal. For some judges it is, for me, and I think for all judges it should be, we want the right result. We want people to be treated fairly. We want to get the result right. And if I don't get it right, thank God for the courts of appeal, because they will, or at least, whatever they say is right. And if they differ from me, they differ from me. It's okay. That's why they've got the nice offices and I've got the cramped chambers.
Thank you, Judge. It's time. There is that signal from another moderator for me to stop.
It's been a real pleasure. Thank you all so much.
Thank you very much. Can we have a group picture so that I will share, so that I will be with you? This is a big opportunity for a retired judge to be with the foreign delegates from other countries.